Alex here with a high conflict child custody video on change of circumstances. This is a phrase that has been brought up to me by many a viewer that is trying to modify custody of their children. And I can usually tell that these are the viewers that have actually looked into the case law or into the statutes of their state a little bit, because it's definitely a thing, at least it is in Nevada. And going off of that train of thought, I just want to mention it's important that you do your own research in your own state when it comes to this, because this video may not even apply to you. Your state may not even require you to show a change of circumstances to modify custody. But for many of us, including those of us in Nevada, there are situations in which that phrase does come up, and one of the most common is when a parent in Nevada tries to modify physical custody of the child. I could go and look into seeing if this is also a requirement when trying to modify legal custody, but my understanding is that it's not a requirement, and if somebody in Nevada wants to look into that and let me know, I can go ahead and pin a comment later on. But my understanding is that it is only required to be shown if a person is trying to modify physical custody of the child, and even then, it only applies if a parent has primary physical custody of the child. If the situation is one where two parents have joint physical custody, they share physical custody of the child, you do not actually have to show a change of circumstances to modify that custodial designation. Now, at first this didn't make much sense to me. In fact, it sounded pretty illogical, but then I found out where the requirement comes from, and then I also found out what the Supreme Court of Nevada says the requirement represents. The Supreme Court of Nevada says that the requirement represents res judicata principles, which I've mentioned in two of my other videos. One of them is issue preclusion, which I'm actually going to have to redo because I've conflated that video with the change of circumstances requirement, which I'm covering now in this video. So I will be replacing that video probably tomorrow to separate out these two different principles. Anyway, the other video is claim preclusion. Claim preclusion and issue preclusion are two species of res judicata. They're also known as merger and bar and collateral estoppel. These are the older phrases that they use to refer to them, at least in Nevada. Other states may still refer to them using that terminology. The point of res judicata is to prevent a parent from coming back to court and either A, litigating an issue that's already been litigated, that would be issue preclusion, or B, litigating an issue that could have been litigated but wasn't for whatever reason. That would be claim preclusion. I'm really glazing over there's a lot of details to both of these types of preclusion. You're going to have to watch those videos to get into how they work, into the nooks and crannies and the exceptions and all of that. But anyway, the Supreme Court of Nevada has mentioned that the change of circumstances requirement comes from res judicata principles. In my opinion, based on how it's applied, it mimics the way claim preclusion works, not issue preclusion, claim preclusion. And I'll go into that more in a second. So it's nice to know what the change of circumstances requirement sort of comes from, but why is it required in some situations and not others? Well, that's because of the statutes. The legislature in Nevada created that requirement by writing it into the language of a statute. When it's not written into the language of the statute, it doesn't apply. Now, the ordinary issue preclusion and claim preclusion principles do apply in any old ordinary lawsuit, but because of the weird way in which child custody and divorce actions work, it ends up being really complicated as to how to apply them, because the way that child custody and divorce cases end up becoming crazy is that the cases don't end like a normal lawsuit ends. With a normal lawsuit, there's a pleading phase, a discovery phase, a trial phase, and then the judgment is entered. There is a post-judgment phase in any ordinary lawsuit, but it's usually very short. It's like to resolve who gets costs, who gets attorney fees, and maybe there's a small period of time in which the judgment is executed on. But with divorce and custody actions, the cases go on and on and on and on. The post-judgment phase can become a 6-year-long ordeal where motions to modify are getting filed all the time, and you're getting all of these post-judgment hearings to assist the court in resolving the post-judgment motions that come up. And so these cases turn into these weird, unending animals that you just don't know where it's going and what's going to happen. And so the way that issue preclusion and claim preclusion work don't always necessarily line up uh, in a way that makes sense when it comes to a case that is just more and more post-judgment after post-judgment after post-judgment motion. So this change of circumstances requirement that's been written into certain statutes in Nevada creates that claim preclusion principle when the court enters some kind of judgment or when a stipulation is signed, something like that happens. A determination is made, whether it's the court that does it or whether it's the parties that do it by coming to an agreement, and of course it has to be approved by the court. That being said, when it does apply, which I mentioned in Nevada, it applies when you're trying to modify physical custody and one of the parents has primary physical custody. It is powerful, just as claim preclusion always has been powerful. In Nevada, if a person is trying to modify primary physical custody, they have to show, at least right now they do, somebody could change the statute later on, they have to show that a change of circumstances has occurred. And what that entails is showing that something new, something substantial, and something new has occurred after the court's previous judgment or the party's previous stipulation. Because a stipulation is a judgment, it's just a judgment by consent. If you don't show that something has occurred since that date and time, something substantial, you cannot even be considered on your request to modify child custody, physical custody. You have to show something new has happened from that date and time. And that's exactly how claim preclusion works in ordinary lawsuits anyway. When somebody sues somebody in court, and that case is closed, whether it's by stipulation or because the parties have gone and litigated the case and the judge made a decision, you can't go back and sue that person again for anything that has already been litigated in that case, and also for anything that could have been litigated but for whatever reason wasn't. The same goes for if you enter some kind of settlement. Everything from that date that could have been litigated or settled on or discussed and wasn't is extinguished, it's gone. If you want to sue that person again, it has to be something new that has occurred after that date and time. And of course there are exceptions, but I'm not going into the exceptions. In fact, if you want, you can watch the video Claim Preclusion because I go into it a little bit more. The same principle is basically attached to certain situations in family law. I don't know why it's not attached to all of them. The legislature didn't feel like doing it. Who knows? But in Nevada, it does apply. It is required. And as I mentioned, in certain situations, for example, as I mentioned earlier, if both parents have joint physical custody, that statute that discusses the change of circumstances requirement doesn't apply to two parents who have joint physical custody. So that barrier isn't there. If somebody tries to modify physical custody when two parents have joint physical custody, they don't have to show a change of circumstances. This, in a way, can cause so much havoc, but at the same time, you can still use issue preclusion to block a parent from bringing up an issue that was already litigated in the past. Issue preclusion works differently, and I cover the details as to how it works in the video Issue Preclusion. As I mentioned, I'm going to have to redo that video, but keep an eye out for it. It should come out tomorrow. The problem with issue preclusion is that a lot of times in family cases, people settle. And a lot of times in family cases, people don't necessarily bring everything to the court's attention when they come to court. Sometimes somebody will come to court and want to address certain issues that have occurred and have other issues that are up in the air that they don't want to deal with now, but they may want to bring up later. And because the change of circumstances requirement doesn't trigger in those situations, you could find yourself in a really frustrating cycle of a lot of old stuff being constantly brought back up over and over again because it wasn't litigated in the past. Now, as I mentioned earlier, if, say, for example, somebody tried to modify custody and let's say a caseworker from the Department of Family Services came and testified, and an expert on personality disorders came and testified, and the court made findings on whatever those witnesses testified to and all that, and the court made a judgment. Under ordinary circumstances, if you look at issue preclusion, those issues will be blocked from being brought up again because those issues were thoroughly litigated. The parties brought them up, the parties were present, the parties battled it out, the court heard the testimony of witnesses and reviewed evidence, and the court made a decision. Issue preclusion is different, and that will be prevented from being brought up again regardless of whether or not you have joint physical custody and you're trying to modify it or whatever issue comes up. It's a different type of res judicata. As I mentioned in the beginning of the video, there's two species of res judicata, and unfortunately, as I mentioned, a lot of times that's not what happens in these child custody cases. A lot of times there's a bunch of settlement going on back and forth, and a lot of issues don't get litigated. And so it can become a trap or an unexpected surprise when a parent, let's say, brought up some issues that they wanted to modify custody on. Both sides decided, you know what, let's just make a deal, let's just go away. And then 2 years later they come back, and because there's no change of circumstances requirement, all of a sudden they want to bring up all of those other issues. And unfortunately, or fortunately, you could look at it either way. That's perfectly fine under Nevada law because there's no change of circumstances requirement. And so even though the circumstances haven't changed, those issues were never litigated. And since they were never litigated, they can bring them back up again. And they're either going to be litigated now or the parties are going to just come to another settlement agreement. That being said, I did want to cover some of the things that the Nevada Supreme Court elaborated on when it came to change of circumstances. The first is the fact that you cannot be blocked from bringing up something prior to the previous order or stipulation if you didn't know about it. And in the Supreme Court of Nevada, they talk about this in the context of domestic violence. So in Nevada, there were cases, and I think this one's called Castle v. Sims, a case where a judge refused to consider acts of domestic violence because it didn't occur after the previous judgment or stipulation, whatever it was, and therefore the parent failed to show a change of circumstances. Well, when this one went to the Supreme Court, they said the problem here is that the parent didn't even know that had occurred. It was completely unknown to them. By the way, this is one of the things they talk about in claim preclusion. So you could see where they sort of draw from claim preclusion to sort of say, yeah, this same principle applies when we're looking at change of circumstances requirements. The person has to have known about it. If they didn't know about it, then it's not barred. It's not precluded. The other issue is if a person did know about something, but they didn't know the extent at which it had occurred. So they raised another example where they said, a parent could have known that there was domestic violence, but maybe they didn't know how bad it was. Maybe it was worse than they thought. These are two exceptions to the change of circumstances requirement. You may not even call it exceptions. It's honestly consistent with the way it's supposed to work anyway. If it's supposed to block you from bringing up an issue that you could have brought up but didn't, it would kind of logically follow that how could you have brought it up if you didn't even know what was going on? Or if you knew what was going on, but you didn't know how bad it was. The other detail that the Supreme Court of Nevada discussed was to be careful not to conflate the change of circumstances requirement and the best interests of the child analysis. And they brought this up in a case called Ellis v. Carucci. The reason they brought this up is because to modify physical custody, it was held that you had to show a change of circumstances and that you had to show it was also in the best interest of the child. You couldn't show just one or the other. You couldn't just show best interest and not a change, and you couldn't just show a change but not best interest. You had to show both. The Supreme Court of Nevada wanted to clarify that the change of circumstances requirement was just one of two analytical prongs. They also called it a threshold question. In other words, you have to answer that question to cross the threshold and move on to the next. So what they were trying to explain to the judges is a parent can only show things from the previous judgment or from the previous stipulation to prove, or you could say show the court that there was a change of circumstances. But once they have done so, they have crossed the threshold, and the next question, which is best interest of the child, is not held to the same constraints. Once you have shown the court that you have a change of circumstances, a substantial change of circumstances, you now open the gates to use anything that has occurred, even things from the past, to show why it's in the best interest of the child. to modify custody. And this also makes sense. If you held yourself to the rigid standard of only being allowed to show the court new things that have occurred, what would happen if a parent beat up their child and then the court made some kind of decision on it, and then you tried to come back and modify custody, and the parent said, no, you can't use the example before where I beat up our child. You can only use the one where I just did it just now. Well, how is that going to help people show a pattern of conduct? Like that would block people from showing, look, this happened now, triggering a change of circumstances, and if you look in the past, you can see that it's a pattern. That would block parents from showing a pattern. That was obvious to me, but a lot of judges were struggling with that. There was, I don't know if I want to call it a quirk or not. Honestly, it's not really a quirk. I'm just going to go into it. The change of circumstances requirement only applies to the parent that's trying to modify custody. This is kind of obvious. That's why I don't want to call it a quirk or a technicality. It's like, duh. The parent who's defending the motion, the parent who does not want to modify custody, they don't need to show a change of circumstances at all. They're not trying to change anything. They're just trying to keep things the way they are. That parent is only having to deal with the question of whether it's in the best interest of the child to modify custody. And so that parent can bring up old things. That the defending parent has no reason as to why they're bound by things that have occurred after the previous judgment. There's plenty of things that could happen that are new. So let's say the child is older now and wants to, they call it child preference. They want to live with a certain parent. They want to exercise child preference, which is something they can do. Well, that could show a change of circumstances because the child has become old enough to show a preference. That would probably satisfy the change of circumstances requirement. But maybe something occurred prior to the previous order that was really scary for a judge. Like maybe the other parent was the parent that the child wants to live with. Maybe that parent had drug problems in the past or committed domestic violence. So that's just an example of how a parent who's trying to change custody can show a change of circumstances, but the other parent can say, okay, well, it's fine that things have changed, that there's new things, but this thing that happened in the past is not to be trifled with. This was serious. They can bring that up to try and prevent a modification. I really hope that this video doesn't come off too complicated to people because there's a lot of odds and ends to it. And when it comes to videos like this, I stress more than anything that you don't just take what I'm saying as gospel and take it to the court, that you actually say, wow, Alex has brought up a lot of details. I need to actually look into this. Not, oh, I'm just going to do everything he says and see what happens. You actually need to look into your state and see if any of these things make sense, if any of these things line up with the way your state works. I also wanted to end this video on a disappointing note. A lot of judges get this wrong, and it ends up leading to a lot of their decisions being reversed on appeal, especially prior to that new case that I mentioned, Nance v. Ferraro. That case actually explains it a lot better, takes all the previous cases and harmonizes sort of the principles that they were discussing and makes it a little bit less complicated and chaotic for the judges, but there still are some judges who just don't get it. I think with that, I'm going to go ahead and end this video, and if anyone has any questions, definitely post it in the comments below. I will see you guys next time.